Mr. Andres, let's go back to that court hearing.
Yes.
The court, the Federal High Court in Port Harcourt, adjourned till further notice on the matter seeking to stop that election. You know that. Was that the court ruling you were talking about?
No.
Because Justice Akombi adjourned sine die because there was a matter at the appeal court that needed to be sorted out. Was that matter sorted out, or is this adjournment that you consider a ruling?
No, there was a ruling by Justice Akombi just last week.
Before this ruling by Justice Akombi,
yes,
he had adjourned sine die, right?
Before the ruling, there was a case before him concerning the entire the integrity of the process itself. Because, as I said, PDP, being a party in this process, did not participate in the electoral process. So they took the matter to court. And Justice Akombi said, okay, pending the determination of all of these issues before me, let the elections not hold. The previous administration went ahead in defiance of this order and conducted the elections, which made, according to Justice Akombi, the process manifestly illegal. So the point is, why do you conduct an election if there was an order stopping it, if there was an injunction stopping it? If you proceeded, then eventually the matter came back to the court for determination. The judge simply nullified the elections and said, these elections we are not supposed to hold in the first place. Now the point is, the chairman went to the National Industrial Court in Bayelsa to get an order reinstating them. But you see, the very logic of their appointment, the very logic of their election has been invalidated already by a court in Port Harcourt. So they do not have a legal capacity to litigate this before the National Industrial Court. So it's very confusing. That's the kind of chaos.
Are you saying that the National Industrial Court cannot determine whether or not he can entertain their suit?
They were not employees.
Well,
the very legality of their status as employees has been nullified by the courts.
I recall that we were watching the news at 10 yesterday, and you know, one of the legal practitioner, Mr. Dutu Ogonye, was saying that it depends on how the reliefs that they sought was framed, and that if they sought it as, you know, in terms of employee-employer relationship, then the court may indeed have entertained their suit.
Yes, but you see, but the fact is they are not employees. The National Industrial Court was established to arbitrate disputes between the employer and an employee. In this case, the very legality of their status as employees has been vacated by a court in Port Harcourt. You were not supposed to be in the council in the first place. You were not supposed to organize the elections in the first place.
Why did the court, you know, finally, because we also understand that there was a hurried reconvening of the court, especially after it had adjourned, you know, sine die?
No, you know, the courts for over, and again, this is just one of the ugly legacies of the Amaechi administration. For nearly 2 years, there was no court sitting in Rivers State. Because every matter concerning elections, even civil issues, we are never, you know, litigated in Port Harcourt because the courts were closed because of all kinds of contentions engineered by Rotimi Amaechi himself. So the point is there were in fact no courts for nearly...
But the Federal High Court was operational.
Yes, but
the question she's asking is, the Federal High Court adjourned sine die, hoping to clarify a matter at the appeal court. Has that matter at the appeal court been clarified?
The matter has been decided last week.
At the appeal court?
No elections,
the case that the case for which reason the Federal High Court adjourned at the appeal court, has it been sorted out?
What the chairman did was to withdraw the appeal.
They withdrew it?
Yes, they withdrew the appeal last week to say, we are no longer interested in appealing. They went to the National Industrial Court. But the point is, you cannot litigate this as an employee when the very capacity upon which you are litigating this has been vacated by a court.
But the court has ruled on it. If the industrial court has decided that these people, you know, we can entertain their suit, or they are still, you know, local local government chairman,
yes,
as it
but
were,
you see,
it can rule on it. Isn't that the same thing that happened at the Federal High Court?
No, it's not the same.
Because the Federal High Court's jurisdiction was still being challenged when it finally gave a court order.
The National Industrial Court's decision was based on the presumption that they were properly elected. But alas, that is not the case, because you approach the National Industrial Court in your capacity, legal capacity as an employee. So the presumption that they were employees was the basis for that judgment. But in fact, that presumption was faulty, because they were not supposed to be councillors, they were not supposed to be chairmen. The election, in fact, into the councils were not supposed to be held. They were held
given on a court order of a court that we're not quite sure if it has a jurisdiction to give such an order or not.
Normally in legal practice, if you have debates about the jurisdiction of a court, you don't resort to self-help. You can launch jurisdictional debates before the court. You don't violate a court order in defiance of your own perception about its jurisdiction. If you think that a particular court does not have jurisdiction, you can instigate jurisdictional debate, not in violation of an order. Okay. So if you think that this court doesn't have jurisdiction to try this case at all, then you can resort to the courts to challenge the jurisdiction, not to violate an order that has been given by the court.
Okay, Dr. Jared, what do you expect to see in Rivers State?
What I expect to see is that, the councillors, and the chairman will stand removed, because they were not legally elected into that place. The process has to be as pure as the outcome. It's just like wanting to get evidence. You get an evidence that appears to incriminate a suspect, and yet that suspect has been tortured before you got the evidence. If you go to court, they will tell you that the evidence is important, all right, but then the process of obtaining the evidence has to be as pure as the evidence. If you torture a suspect and obtain evidence, it might be convenient for you in the beginning, but in the final analysis, in the course of actual litigation, that evidence will be of no use, because they say it was obtained under duress. So the process has to be as pure, has to be as legal, has to be as valid as the outcome. In this case, elections were held, but in fact, they were not supposed to be held because there was a matter before a judge, and the judge has said, wait until such a time when all of these issues are resolved. You violate that order and conduct the election. And the judge is saying, no, you could not, in fact, have held those elections because you were in violation of a court order. In fact, they ought to be held, according to the judge, for contempt of court.
All right, thank you very much. We've been speaking with Dr. Austin Tam, Judge, Executive Director, Institute of Communication and Corporate Studies, Lagos. Thank you for coming.
Thanks for having me.